once either by their questions or by their contributions. So once they are not around, it is usually obvious. So today we will continue on this trajectory because we expect to have questions. We expect you to embody these principles such that it becomes one with you, that as you're drafting, it is ringing somewhere in your subconscious. Okay, this, as I'm taking this brief, this should be done, this should be done, this should be done. When you are done with receiving your instruction and you are drafting, you should also have it at the back of your mind. When you are doing your scrutiny, you should also have it at the back of your mind. So what did we say is miscellaneous provision? We said that miscellaneous provision, or the word miscellaneous, comes from a Latin word, miscellus. Miscellus also is presumed to have come from the Latin vulgar verb miscule, meaning miscellus is spelled MISCLLUS. While misculare is spelled MISCULARE, which means to mix something together. To mix something together. If you have seen builders where they are mixing sand and cement for plastering purposes, that's the picture painted here. To mix things together. Then the etymology, miscellaneous, that is MISCELLANEUS, Latin noun, is made up of miscellus, which is an adjective suffix, and enus, ANEUS. Now there is more like a dash on top of it, or a hyphen. Of course, it's Latin. Now the suffix enus may have come from collectenus, which means assembled from various sources. And that is how we got the word miscere. Miscere, MISCRE, which means mix up. So we are tracing the roots, the etymology of the word miscellaneous, the origin of that word. Then in legislative drafting, miscellaneous provisions are the part of the bill or legislation that contains a mix-up or assortment of provisions that are designed to cover up any loophole or circumstances that are not covered as part of the principal provision. This is the purpose of miscellaneous provision: to cover up any loophole or any circumstance that are not covered as part of the principal provision. Understand that the preliminary provisions are the introductory parts of the bill, the initial parts of the bill. The principal provision is the main thrust of the bill, the meat of the bill. Then miscellaneous provisions helps you to cover up any loophole, any gap, any circumstance that is not covered in the principal provision. The miscellaneous provision helps you. And how does it do that? It helps you to ensure or to achieve the implementation of the principal provisions. Subheadings under miscellaneous provisions are as follows: offenses and provisions ancillary to offenses, such as time limit for prosecution, continuing offenses, offenses by corporations, and vicarious liability. That is one under offenses. Miscellaneous provisions are supplementary provisions such as evidentiary provisions. 3. Power to make subordinate legislations or subsidiary regulations. 4. Service of notices. Power of entry, search, warrant, seizure, and arrest. Licensing and registration. Provisions that cover the appointment of a licensing authority, the object of its activity, and the manner of application for the license, the sanctions for breach of the obligation to obtain a license, or any fraudulent behavior. What I'm reading out is already on the in-call messages. You can follow it up there. It also talks about jurisdictions, appeal procedures, inspection issues. So miscellaneous provisions is an assortment, different clauses that make up these provisions. So let's look at jurisdiction, for example. We're saying that when you create an act, or when you create an offense, rather, or when you prohibit an act, making it an offense, making the doing or not doing of that act an offense, you are supposed to specify a court with jurisdiction to try that offense. You do not just assume that any court can try it, and that failure to make that provision might make it difficult for the enforcement of that provision of the law. And we cited the example of the Nyanya bomb blast case, Terrorism Prevention Act. The first enactment of that act omitted to arrogate prosecutorial authority or to ascribe prosecutorial authority to a specific agency of government. So the suspect in that case, Kabiru Sokoto, was arraigned before a high court. Then, before a federal high court. Then the DSS came as a prosecuting authority. The Nigerian police came as a prosecuting authority, because the law, the Terrorism Prevention Act, as it then was, did not specify a prosecuting authority. So the counsel to the defendant smartly harnessed that loophole and raised an objection, a preliminary objection, to say, my lord, neither the DSS nor the police was assigned under the act to prosecute these defendants. They do not have such powers. And the court struck that matter out, because there was no specific or named or identified prosecuting authority. Now, the effect of that is that the media have seen a news item to sell their paper. So they will give it one sensational headline: court frees bomb blast suspect. Full stop. And people will start talking. People will abuse the judge. People will insult lawyers. People will abuse the police. People will abuse the DSS. Yes, the judicial system is corrupt. They have bribed the judge. people will cook up all manner of stuff, drafting incompetence that led to that. So the judge has to strike the matter out. The bill or the act has to be sent back to the National Assembly for amendments. Precious time of the judiciary has been wasted. State resources has been wasted. The National Assembly or the legislature will have to sit again to amend the law to now name a prosecuting agency. You see what it will cost to get the law amended, where we omit to put in the right clauses in the miscellaneous provision. Another example on jurisdiction is, what's the second case now? God help me. I mentioned the case of the bomb blast. I will remember another example on where the court did not, okay, James Ibori's case. James Ibori was the former governor of a state in Nigeria, and when he left office, he was charged, he was facing corruption charges by the Economic and Financial Crimes Commission, EFCC. Now, the first EFCC Act also suffered this fate. It did not name a particular court that has jurisdiction to prosecute an economic crimes offense. So then, if you drag Mr. Ibori to Federal High Court, his lawyers will raise objection. My lord, this court does not have jurisdiction. It is the act, it is the Establishment Act that confers jurisdiction on a court. The court does not just arrogate jurisdiction to itself. If you took him to High Court, you raise the same objection. So the news papers we are selling, because they will go to court and the matter is struck out and the media will sensationalize it to sell their paper. And the judge will be accused of collecting bribe. EFCC prosecutors will be accused of being compromised and all whatnot, until the EFCC Act was amended to name specific courts that have jurisdiction to prosecute. Now, as at last count in 2023, the EFCC Act has undergone 52 amendments. Why that so many amendments? Because of inelegance in drafting. So once you go to court and test it, something will come up, you will have need to amend. And we have stated that the test of the effectiveness of your bill or law that you drafted is its ability to withstand judicial pressure, the pressure that comes from the courts. If it survives litigation in terms of interpretation and goes through that crucible and stands, you will know you have done a great job. We also, issues that relate to service of notices. When you establish a statutory corporation, you give them power to sue and to be sued in that capacity. Now, is there need for them to have pre-action notices? What's the procedure? If you want to sue a statutory corporation, do you just wake up, you felt offended yesterday, or they abused your rights, or what, they committed an offense, they flouted a procedure, or you want to now enforce the provisions of the law? What did the law say? If the law provides, if there is need for them to have pre-action notice, you do not assume that every lawyer should know that as a statutory body, you ought to serve them pre-action notice. No, you put it in the Establishment Act that before you can sue this agency of government, before you can sue this statutory body, you have to serve them 3 months pre-action notice. You put it in the miscellaneous provision. If that pre-action notice is not there, anybody can wake up and serve them court processes any day. issue of protecting the interests of staff. This staff of this corporation, this staff of this agency of government, are they supposed to be pensionable? Are they supposed to have their pensions? If yes, if that is what you want, you put it in the miscellaneous provision that this staff should be entitled to pension. If they are to be protected under the Public Officers Act, you put it there, because there is no room for assumption in our laws. If it is not written, it is not written. So the essence of preliminary miscellaneous provision is to cover any loophole whatsoever. Then we now put this omnibus clause, which is conferring power on the head of that agency to make subsidiary regulations to ensure the implementation of the Establishment Act. Meaning, since you as a drafter, you are not all-knowing, you will not know, there are things you will naturally not foresee. Some things might come up tomorrow. You have drafted and this law has been passed. You will now give the head of that agency power to make subsidiary legislation to ensure the implementation or the achievement of the provisions of the principal provisions. So what it means is that even if you didn't foresee some things, the head of that agency can now make regulations to cover those loopholes. But if you did not give power to make regulations, it means it is only the way and manner you have said this law should be implemented, that's how it should be implemented. Meaning, if there is a roadblock tomorrow, that law has to be sent to the National Assembly or the State House of Assembly for amendments before progress could be made. Whereas if you had put that power to make subsidiary legislation, the executive director will just come up with a draft subsidiary legislation on procedure for enforcement or further procedure for enforcement, and that will be done. So that is what miscellaneous provision does. We used an analogy that miscellaneous provisions is like the bag of a woman. It has different things inside that bag. That bag contains different things. You can see safety pin inside the bag. You can see needle and thread inside the bag. You can see clip that they use to hold clothes inside the bag. And they all have different functions. Some of them could be for preventive purposes. I said somebody might be going and just have thread and needle, just in case he's passing somewhere and her skirt gets torn. So instead of facing embarrassment, the person can quickly tack it and move on until she gets to either where she can buy new clothes or get some to change this one, but will not be foisted with state of helplessness. So any questions, please? Any questions? Any questions?
Hello, Ebenezer.
Yes, my brother.
Can we get the full citations of the case you just referred to? Is it possible to have them so that we can go through them?
Okay, I will get the citations for James Ibori cases, then the citation for the Kabiru Sokoto case. We'll just put the name, yes. Any other question, please? Any other question? If there is none, may I ask my own question? somebody should, Joyce, welcome. Madam Uju, welcome. Mr. Kingsley, welcome. Somebody should give us at least 6 clauses under miscellaneous provisions. At least 6. 6 clauses. There are more than that. But give us at least 6 clauses that should be under miscellaneous provisions. Any volunteer? If there are no volunteers, I will call names. Mr. Charles, you have been consistent in class this week. Can you give us 6 clauses under miscellaneous provisions? Any 6, not in any specific order. Any 6 of the clauses that should be part of the miscellaneous provisions.
Hello?
Yes, we can hear you, sir.
Yeah, I'm driving, I'm sorry. Just in the middle of traffic, but I will try.
Okay.
I think you put jurisdiction. Yeah. You put jurisdiction
Sorry,
as one
I
of
didn't
the
get that.
jurisdiction.
Jurisdiction. Yes, tell us about it.
Jurisdiction, it simply means the jurisdiction of which on which the applicant or anybody who is doing can actually refer the matter.
Hello? Yes?
Yes.
We didn't get that. You said jurisdiction means?
I'm saying that's where the matters pertaining to this particular legislation
Yes.
will be referred to.
Okay, awesome.
Yeah.
Jurisdiction. Yeah. By jurisdiction, we mean not just the court that has jurisdiction to prosecute, but also the prosecuting agency or the prosecuting authority.
Yes.
Good.
Or any dispute relating to that particular legislation.
Yes. Hello, sir. We didn't get that.
I'm saying, or any dispute that that actually relates to this particular legislation or that particular legislation at a given time. Yes. I'm sorry, I'm driving.
Okay. I'm sorry. The time of prosecution.
Yes.
Okay. Let me just elaborate. Let me just give specific examples. Here in Nigeria, the limitation of action, the time within which a medical negligence claim can be brought to court is 3 years. We are talking about time limit for prosecution. If you have a medical negligence case, the time within which you can prosecute that claim is, or institute that action, is within 3 years of the occurrence of that negligence. Yes, after 3 years, you can no longer bring that action. If you brought it after 3 years, the other lawyer will plead limitation and telling the court that your case is statute barred, meaning the time frame within which you are supposed to bring your claim has elapsed. In our
language, we say it has prescribed. We call it a prescription. It prescribed.
Yes.
Yes.
Yes, yes, you are correct. You are correct. So you have mentioned jurisdiction, you have mentioned limitation of action. So we still have 3 more to go. So can someone else help Mr. Charles? Mr. Charles, thank you very much. I understand you're driving, so you also need to concentrate. Thank you, sir. So,
Maybe. Hello.
Hannah, you are welcome. You have also been part of the class since this week. Yes, I'm with you, sir. Yes.
I think maybe the regulations maybe will be part of the miscellaneous. Regulation.
Which regulation, sir?
Regulations.
Yes, which one? You have to qualify the regulations.
When we have this particular act,
yes.
the minister or whoever is in charge will be given the power to make regulations. So I'm saying that part will also be within the miscellaneous.
Yes, I understand you. That regulation that the minister is empowered to make, what is the appropriate name? What is the appropriate name of that regulation?
Maybe the bylaw or whatever. Let me see.
Okay.
I don't know.
Bylaw is made by the local government. I understand what you're saying, but for the purpose of, how do I put it now? For the purpose of the language of this area, for the purpose of the terminology or the technicality of this area, you will say they make either subordinate legislation or regulation or subsidiary regulation. Because it is also a law, but it's just a law that is made deriving their power not from the legislation but from the principal act.
Okay. So I'm at 4 now. There are 4. We have 4 now. So there's also what we call transitional provisions.
No. Transitional and final provisions are in transitional savings, and transitional provisions are in the final provisions. That is what we will deal with next week. Savings and transitional provisions are part of the final provisions. Yes, that's what we will deal with next week.
Okay.
Yes. But you might see a bill and the person, the drafter, will mistakenly put the savings and transitional provisions under miscellaneous. No, they are part of final provisions. So that is what we'll be discussing next week. But you have tried, you have mentioned jurisdiction, you have mentioned the limitation of action, you have mentioned power to make subsidiary legislation. Thank you. So who else can contribute to this? Who else can contribute to this? Okay, let me call another person. If I do not see any volunteer, thank you, Teboho. You have your hands up. Yes.
Yes. I think we may also have provisions covering issues of inspections.
Yes. Inspections.
Yes. Mm-hmm. And then the issues of arrest and seizure.
Yes. Warrants.
Mm-hmm. I think you talked about application for licenses.
Yes. They put not just the application for licenses, the officer in charge of that, the procedure of applying, where you fail to apply or obtain license, what the penalty or punishment will be, or default fine, all that are under licensing. Yes.
Also the appeals, I think, where you are aggrieved by the decision taken by
the procedure to register your displeasure, the procedure to appeal the decision of the commission or the decision of the agency, the procedure to appeal. Yes.
Maybe I may even come in again.
Yes, please.
I think we have offenses. Did we mention offenses?
Very important.
Offenses.
Yes.
Did we mention that one? Did anyone mention?
No, I said I am commending you for bringing it up.
Okay, that's offenses. I think it's one of them.
We have offenses. We have limitation time for offenses, or for prosecution, continuing offenses, offenses by corporations, vicarious responsibility or vicarious liability, where an employee of an agency commits an offense, who is liable? If you are suing, what are the parties that you are going to institute an action against? Then we also have issues of notices. Yes, even notice for meetings for statutory bodies. If they are going to have a meeting, what is the mode of conveying the notice for that meeting? Who is responsible for issuing that notice? What is the duration of that notice? Issues of quorum are all here. Then you want to talk about pre-action notices. If you want to sue the corporation, do you just wake up, you had an issue with them today, tomorrow you go and file? Is there a provision for pre-action notice? If there is, what is the duration of the pre-action notice? So you do not say, for instance, that anybody who wants to sue this corporation, we have to issue pre-action notice first. Now, that is not, it does not make any sense. What is the duration of that pre-action notice? Is it 1 month? Is it 1 week? Is it 3 weeks? Is it 3 months? So you have to be specific about duration so that it will be complete. Now, if you say the person has to issue pre-action notice, it is ambiguous. Once the person serves you 3 days pre-action notice, you cannot come and say that the pre-action notice is incompetent because it did not meet the required time. And when they ask what is the required time, you say under NMPC Act, it is 3 months. So it is presumed that this one should be 3 months. No. If you want the pre-action notice to be 3 months, you state it there. That the pre-action notice should be 3 months before any litigation or any suit is filed in courts. Next.
I think I'm worried now. Hello.
Okay.
I'm worried.
Okay.
I'm trying to check one of the acts we have here.
Sir?
I'm aware that the transition clause is actually under the miscellaneous. Is it wrong? Is it wrong?
No.
I have here with me Public Procurement Act of 2003. So I see the transition
Sorry, you said you have what documents?
I have Public Procurement Act of 2003, Lesotho
Awesome.
Procurement. Yes.
Okay.
I have it here, but I'm aware that the transition clause actually falls within that part, which is miscellaneous.
Okay.
So I'm saying, is it wrong? Can you
actually say it? That is why we are in this class.
I'm checking another one. I'm checking another one here. I'm just.
It is wrong. That is why we are in this class. Transition, savings and transitional provisions or transition provisions are under the final provision. Savings and transition clauses, rather, are under final provisions. Now, yes, and that is what we are going to be dealing with by next week.
Okay, I also have this one, Companies Act of 2011.
Sorry, I didn't hear that.
Companies Act of 2011.
Yes.
Yes, our Companies Act. The
yes.
Companies Act. It has general provisions relating to liquidators, rules of procedure, the power of attorney, service of document on companies and in legal proceedings, service of other documents on companies, service of documents on shareholders, additional provisions relating to service, regulations, rules, and repeals. But this one does not have the transitional clause. But this one, procurement Act, Public Procurement Act of 2003, it has that. It has.
Okay,
the
now.
Transition clause actually falls under the miscellaneous. Okay.
Okay. Now you know better. You know the other day, I sent us snapshots of our AJA, Administration of Criminal Justice Act 2015, showing that they got the commencement part of the preliminary provision right, but they mistakenly put in purpose clause, and it ought not to be, because we're a common law jurisdiction, we do not use purpose clause, but it is contained there. I also showed us the other acts where rules where they put purpose clause, they use the round brackets for commencement. Two, the first bracket, the first round bracket, they put the date inside. Then the second round bracket, they wrote commencement inside. Both of them are wrong. So the essence of this training is for you to now be able to identify those mistakes, that once you pick a bill, once you pick a law that's already in operation and you look at it, you can say, there was a drafting error here, there was a drafting error here. And whenever opportunity comes for it to be amended, you can submit a memorandum in that regard to say, kindly correct this place. This is how it should be. This is how it should be. You now talk from a point of knowledge and a position of authority as an expert in this area. I don't know if you understand me, sir. Hello? Hello? Did you understand what I said? Sorry, please, can anybody hear me?
Yes, we
Yes,
are.
we can hear you.
Okay, okay. So I said, I hope you understood my explanation now.
Yes, we did.
Okay, thank you very much. Okay, last week we gave an assignment for week 6, and only few persons have submitted the assignments. So I am using this medium to urge us all to attempt those assignments. It is in doing that you are perfecting your knowledge. It is in doing that you are getting to know. So please, by next tomorrow, the assignment for week 7 will be out, and we expect you to also do and submit. However, I have noticed that a lot of your colleagues, particularly our Lesotho brothers and sisters, have dropped out from the training. Kindly find out what the reason might be, because it is only those who complete the training that will be issued certificates when they apply for it and they meet up the processing requirements. So please let your colleagues know that the class is getting thinner and we are worried about why they are no longer attending classes. I think in the absence of any other question, we will be ending the class here, and we'll reconverge tomorrow.
Thank you.
Thank you, everyone.
Thank you.
Thank you, sir.
Thank you.